Hey guys, and welcome back to today's video. What you're about to witness is another courtroom showdown where confidence collides with reality. The defendant enters believing he has uncovered legal loopholes that will instantly dismantle multiple criminal charges, but the judge has seen these tactics many times before. As the hearing unfolds, you'll watch constitutional arguments, procedural challenges, and repeated attempts to convince the court that the entire case should simply disappear.
Okay, so the people versus Daniel Magoo. State your name.
Daniel Magoo.
All right. What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523, I have a couple things I'd like to point out about a couple of the matters here today.
Go ahead.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that that charge is invalid on its face.
That were going to be addressed. That would be addressed at the preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenged the prosecutor to prove all three.
Sir,
Yes,
you
sir.
wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed, a motion for all dismissal on all these charges.
Right from the beginning, the defendant wastes no time launching into statutory interpretations and legal definitions, hoping to convince the judge that one of the charges is invalid before the case even reaches a preliminary examination. While defendants absolutely have the right to challenge criminal charges, timing matters in court. You can already sense the judge carefully listening while also making it clear that this courtroom is going to follow established legal process rather than shortcuts.
Those videos and those will be sent interdepartmental to jail staff to serve on Mr. Magoo, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the
He
video.
has all video discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure yet.
So, Mr. Magoo, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So, given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a speedy trial.
So you want your preliminary examination. Those are coming down to the jail to him.
Yeah, I expect that he would have them early next week, so if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th and then
Have them as well.
he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination, this being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 4 different counts, or 5 different counts, excuse me, including and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200, nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a 3rd offense notice, which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service, any rehabilitative programs the court deems necessary. Court could order you to pay the cost of the prosecution, plus the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, excuse me. That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court costs. Mr. Magoo, yeah, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I will. I have requested assistance, given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be
Well,
represented by?
I've called the
Well, Mr.
prosecutor.
Magoo, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorable.
As the hearing continues, the defendant shifts from challenging one charge to attacking nearly every allegation against him. He repeatedly references constitutional protections and insists the prosecution will be unable to prove the required legal elements. While raising constitutional issues is completely legitimate, merely asserting that the government cannot meet its burden isn't enough to dismiss a case outright. The judge's responses show an important principle of the legal system. Factual disputes are usually resolved through evidence and testimony, not assumptions.
Thank you, Judge. Torture, Officer, Assistant Public Defender, on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set these for preliminary examination.
Okay.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested. And this triggers due process violations under US versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations. And I do request that the prosecutor provide or provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. And I'm just requesting that the court grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors.
In response from the people regarding his bond.
People would ask about the continued and he also at the bench for failed to appear before the judge's plays. So
Yes.
that warrant would also with respect to the other I'll wait. There are pleadings filed by the defender's office. Our office will respond to that. And I guess my one remaining point would be, should with the court's appointment Eastern the Public Defender's Office, I will make sure that the digital discovery that I referenced is served on the Defender's Office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still being held, regardless of what the bond would, in this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied. So
That's what I
would
Mr. Cho decide.
in any event. But also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case,
I have,
that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And,
I understand the presumption of innocence.
and a lot of these are facially invalid, Your Honor.
The discussion now turns toward discovery and scheduling, reminding everyone that criminal cases are built on evidence, not speculation. The court ensures that both sides have access to reports, videos, and other materials before moving forward with a preliminary examination. Although the defendant expresses frustration about delays and invokes his right to a speedy trial, the judge balances that concern against the need for a fair process. It's a good example of how courts often prioritize giving both parties adequate preparation over rushing into a hearing that could later be challenged for procedural unfairness.
On that date, for both of these cases, I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh, yeah, in that regard, Your Honor,
Many of those do not interrupt me. Including many that I don't even know the connection. Court has this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I would deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there, they will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people of individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So.
I'm aware that such filings were being received by our office maybe yesterday. At this point, we continue to proceed with this case, and a lot of time until I hear otherwise from the elected prosecutor.
can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction.
One of the biggest turning points arrives when the judge asks a simple but extremely important question. Does the defendant actually want legal representation? After previously insisting on representing himself, he finally indicates that he wants legal assistance. That decision may prove to be one of the most significant moments of the entire case. Criminal law is incredibly complex, and experienced attorneys understand courtroom procedure, evidentiary rules, and legal strategy in ways that most self-represented defendants simply cannot.
And this matter comes before the court today on Ms. Campbell's request to terminate the personal protective order that I granted in favor of Ms. Gay back on June 14th of 2025. I do have to tell you, both ladies, and apologize in advance. I have gotten us behind just through my fault and my failure to move these cases as fast as I'm supposed to move them this afternoon. So I'm a little bit short on time. I don't have time to take extensive testimony on it. I think what I'd like to do is let me see here. Okay, so we're just going to have to keep it quite short. And I guess the way I'll do it is I'll swear in Ms. Gay, take her testimony as to the basis for the PPO. I will hear in a response from Ms. Campbell why I should terminate the PPO, and then I can make a ruling. So, Ms. Gay, if you would please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Very good. And to support this protective order, you stated that there were a couple of incidents here, one of them being Ms. Campbell throwing eggs at your house. Tell me what happened on that occasion.
After the incident happened, after the altercation with, her and everybody else on the Hall Street,
Yes.
they threw eggs at my home.
Was
and
it
then
during that same big brouhaha on the blow up, or was it later that day or in the evening? When did it happen?
later.
Okay.
And
All right.
then
And who were the egg throwers that you saw?
Renee and her daughter.
And you saw them actually throw eggs at your house?
Yes, because the next day she was on the neighbor's porch, just keep yelling. I didn't throw eggs. I have cameras all around my home, all around it. And I have my cameras, if you come anywhere towards my perimeter of my property, it captures you. It was her and her daughter. They were throwing eggs. And then the next day, she was on the neighbor's.
Even after requesting counsel, the defendant continues raising constitutional arguments involving due process, pretrial delay, and alleged violations of his rights. These issues can certainly become important under the right circumstances, but they generally require detailed factual analysis rather than broad assertions. The judge listens patiently while separating legal questions that may be addressed later from requests that simply are not appropriate at this stage of the proceedings. It's another reminder that courtroom success depends not only on what arguments are made, but also when and how they are presented.
Out of concern because of her threats to harm me.
Okay, and my next question, you said you submitted the films, you submitted them to the police department? When they
Yes, I
report?
did. The lives that people were sending me, as soon as they sent them to me, with her ranting and raving about how she was going to kill me, I went right downtown to the police department and I sent it to them. That's two of her telling me she's going to threaten me. I got one actually with her video, and I have her ranting in the backyard, just yelling and screaming and scaring my grandkids, telling them that how she's gonna hurt me. And it just went on and on. And I have witnesses, guests over, like, oh my God, you have to listen to that. I'm like, yes. She keeps
Okay,
threatening
well,
me.
let me see what Ms. Campbell has to say about it. Ms. Campbell, would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, I do.
Very good. Ms. Campbell, you
Well,
say in your response here, you think there should be a termination. Um, it does say you're off probation. What were you on probation for?
I was on probation for the incident uh with her daughter and stuff, and ever since I've been off probation, she's been harassing me and my I have an 18-year-old daughter. And so she has a daughter that's my age or whatever, and stuff. So basically, ever since that incident, she's now that her daughter, so she basically got her daughter, her grandkids, and like her nieces and them making up stuff. I never once threw eggs at her house. I never said nothing to her. She came to my house, her
I
and her
did.
daughter and her
I
grandkids.
did.
I
Hang on,
never
you gotta let her testify, Miss Gay, and then I'll give you a chance to respond.
I never now since she came to my house, that was May 31st. I have two incidents from this year. May 31st, which I put in the
When the conversation shifts to bond and public safety, the judge carefully explains the reasoning behind denying the request for release. Rather than focusing solely on the defendant's personal claims, the court considers the nature of the charges, prior circumstances, and the potential risk of failing to appear. Whether someone agrees with that decision or not, the explanation illustrates how judges must weigh multiple legal factors before modifying bond conditions. These decisions are rarely based on emotion. They're intended to protect the integrity of the judicial process while balancing individual rights.
something. That's when she's making these reports. I never threw eggs at her house or whatever, and I would never turn my 18-year-old daughter to throw eggs at her house. She called she said she never called the police. If I threw eggs at her house, why didn't she call the police? She came over here with a mob of people, her whole generation and stuff. It's only me and my daughter and my 9-year-old daughter. You look, I have a 9-year-old daughter and an 18-year-old. Today my daughter turned 19, so they're 10 years apart. That's not true. I never said I left in an ambulance. They assaulted me, her and her kids. And she has the background. You can look on the camera. She drove her car over to my house. I never once went over to her house. She
Well,
came
that
over
you're
to,
talking about the big fight that happened in the street on Zeno Street
it didn't have, it happened on Hall Street, not
or on Hall
Zeno.
Street? Okay.
Yes, she came over, her family came over to
Yeah,
my
I
house.
don't want to reissue the fight because she's saying, well, since that fight, this
Nothing never
thing
happened.
escalated.
Since after that, yes, she's been calling CPS. They've been calling the city. They've been calling, making, now she's trying to do a PP or interfere in her life or whatever. Lady, I've been staying here for 3 years. I never, come on now. I never said nothing to her. I never, some eggs. It,
And you're not yelling at her from the back porch where she could
no,
hear from her house.
I am not. You can ask the judge. You could get active and come to the neighborhood. I've been staying here. They saying that me and my kids, now she's going around saying my 9-year-old daughter with a taser. They brought the taser to the fight, and then my 9-year-old daughter
Yeah,
picked it
well, the
up.
taser's not part of this
I
PPO, so
know,
I'm gonna
but
leave that thing
but it
alone.
was led up to, it's what leading up
Yeah,
to this
I get
mess
it.
or whatever and stuff. Um,
Let
I
me
never
bounce
said
back to
nothing.
Miss Gay and I ask her about that. Miss Gay, have you been making CPS calls about Miss Campbell's parenting?
I have never called CPS. Miss Campbell, Judge, I have proof of everything that I've submitted. I have proof of her. I have my ring camera is what her coming in the backyard yet threatening me. I also have her on Facebook. I have all of the recordings. As far as her talking about, I came around and Miss Campbell don't understand it. She doesn't want to tell the truth. When I came around there, I tried to ask them not to have any altercation, and she keeps making up this stuff like nobody wants to harm her. I don't have no business like messing with her, and she doesn't have any messing with me. I'm not that type of person. She was found guilty for whatever reason with her and my daughter. I don't get in that stuff. I'm a whole grown person and an individual. I ask that you please.
By the end of this hearing, the judge leaves little doubt that the case will continue through the normal legal process rather than ending with early dismissal requests. The defendant is given the opportunity to challenge the charges during future proceedings, but the court makes it clear that evidence, not unsupported assertions, will determine the outcome. It's another fascinating example of how courtroom confidence alone rarely changes the course of a criminal case.